All right, I'm going to go ahead and get started. We're still missing a few people, but I know you all have busy schedules, and I want to get this moving along as quickly as possible. So first of all, I want to thank you for joining. We're conducting two sessions today, two similar sessions on the advisories that the authority has been issuing within the past, well, since January, to help streamline the application review process. For those of you who may not know me, I'm Tom Donahue. I am now, at least since January, I've been the Deputy Commissioner of Licensing. I am going to focus on those advisories that do address the application process. There are some other advisories that the members have issued recently. For example, a change in the supplier wholesaler marketing permit. I'm going to go through the main advisories, kind of like by topic rather than by individual advisory. And then at the end, if anybody has questions about those advisories that I've discussed, or ones such as, say, the supplier marketing permit, we'll take those questions then. All right. So with that, I'm going to start, I guess, with what is the easiest topic. And those are the items or the documents or the information that will either no longer be needed or will be revised as far as forms. First off, as those of you know, many of you know, is that we issued an advisory that would allow applicants to waive the submission of certificates of occupancy or letters of no objection until the first renewal period. We have now eliminated the need to submit those documents at all. So that covers the certificate of occupancy, the letter of no objection, and for some applicants, the public assembly permit. All right. If you have a current application and you've received a deficiency regarding one of those three things, or if you have a renewal where you have a deficiency regarding one of those three things, feel free to reach out to the agency, whether it be the examiner or the deficiency email box or the renewal email box, so we can get that item removed as a deficiency or as a condition of approval. Staff is trying as best we can with our current workload to identify those applicants, but we're going to miss some. So if you have an application that this pertains to, reach out. Along with that, the certificate to collect sales tax will no longer be needed. You will not have to submit the proof of workers' comp or proof of disability insurance. Right now, it will take us a little while. I'll have to admit, to get the applications updated to eliminate those questions. If you're filling out an application and you just skip that, don't worry, you're not going to get a deficiency, right? Because the staff knows that is no longer needed. Again, if that's a condition of approval or a deficiency that you're dealing with, reach out to us so we can move that application along. And when I say reach out to us, please don't email me directly. All right, I've already had a few of those, and we have some 3,000 or plus applications pending, and I can't be dealing with the individual applications and deficiencies and conditional approval issues. The statement of area plan, for whatever reason, we make all the licensees fill this out, or have been, or all the applicants, even though it only pertains to on-premises liquor and package and wine stores. So going forward, those will be the only applicants who have to fill that out. Same thing with the right to premises form. All right, well, let me back up for a second. The landlord identification form, we are going to change that. There is that section on the form that requires the licensing history of the landlords, you will not have to complete that. Right? We will get a new form out, but for now, you can use the existing form. Just, if you want to draw a line through it or just leave it blank, don't worry about it. It will not be considered a deficiency in the application. Proof of citizenship. We are not going to be asking for that anymore. Okay, there will still be a question on the application regarding citizenship, but we are not going to be asking you to submit the documentation to back up that. Now, I want to make clear that for all these things we're removing, there are certain things that, for example, citizenship, right? That is a licensing eligibility issue. So representations made in the application with respect to citizenship and some of the other things we're going to be talking about, the applicant's still bound by those. So if down the road there's an investigation and we found out the applicant submitted a false statement, they will be subject to disciplinary action if they have the license. Diagrams. This is particularly for on-premises retailers. All right. We're not going to be worried about where your tables and chairs are anymore. All right. So we're looking for the rooms. We want you to identify the use of the rooms. We want to know where the bars are. We want to know where the stairways are, the entrances are, if there's a stage, if there's a DJ booth, things like that. We don't need to know where the sink and the refrigerator in the kitchen are. We just need to know which room is the kitchen. All right. So we're trying to kind of make it easier for you to submit the diagrams for your applicants. You may remember some time ago, we issued an advisory that simplified the diagrams for manufacturers. That they didn't have to put in all the pieces of equipment and so forth. So this is kind of along the same lines. The right to premises form, right? We're going to tweak that a little bit, right? That's where you're going to be putting in whether or not there's a percentage clause in the lease or some other agreement, right? You will still have to submit a lease or a deed, a signed lease or deed, or a fully executed and binding letter of intent. We are not going to be reviewing them in detail. I know from my experience here that years ago it would not be unusual for an examiner to go through a lease and find some clause in there regarding the use of the premises. I recall one where there was a package store and the lease said the premises had to be used as a bookstore. That's not our problem. That's between the applicant and the landlord. Right? We are concerned with whether or not the lease, the deed is in the name of the applicant, whether the lease is going to run the length of the initial licensing period, making sure it's signed. We're not going to look for the percentage clause. The applicant is and currently has to disclose whether or not there's a percentage clause in there. So if that's misrepresented, down the road, the licensee will be facing, disciplinary action for that. I just want to throw in here at this point, I'm not going to talk about the third-party provider advisory that was issued last summer, right? But that plays into both the right to premises form and also some of the other topics we're going to discuss as we roll along here. Next topic is package and wine stores. So the first thing we did, and it may just seem like a common sense thing, but apparently there was a practice here we had to change, had to do with determining with the old neighborhood removals, which probably all of you are, know what that means. Those are the removals within a certain distance of the package store's current location that don't have to go to the full board. If there's no, according to the licensing board delegation, if there's no change in the 4 closest stores, that application, provided that the size of the store is not increasing by over 25%, don't have to go to the full board. As I found out here when I moved to licensing, was that we were using the four closest, and we were comparing the four closest from when, say, your client first got its license, perhaps 10, 15 years ago, with the four closest from when they would be moving now. That didn't seem to make any sense. All right, so we're taking now a snapshot. When the removal application is filed, we're going to look at the four closest that are currently, that your client currently has, and the four closest at the new location. If they're the same, then, and you're not increasing the size over the threshold, it doesn't have to go to the full board. It just seems a simpler way to do that. Along with that, it had come to my attention that when an applicant was looking to buy an existing store and then immediately move the store someplace else, we were treating that as so in other words, they weren't going to open up at all in the location they were buying. We were treating that as both a transfer and a removal. So we would essentially have the applicant file for lack of a better term, a dummy application for the transfer, and then the removal application. As a practical matter, we could never actually approve the transfer because your client was never ready to open and operate at the first location. This also created somewhat of a loophole for neighborhood removals. Someone could go in with the transfer application for the store they have no intention of opening at, seek to remove within the parameters of the neighborhood removal, and avoid going to the full board. That loophole is now gone. So if you have a situation where you have a client who wants to buy an existing business, an existing package store, wine store, but doesn't plan on operating there, wants to operate someplace else, you need to file a new package store application, and that's going to go to the full board just like any other new package store application. Now, feel free to, when you're arguing public convenience and advantage, to point out that you bought a store, or store can argue that you're replacing that store, okay? But it's going to be reviewed as a new package store application. The street level. This has been an issue going back for years. And I can recall being at board meetings back in 2006, through Chairman Boyle's term, where if you were step up, you were not on street level, you could not get that location licensed. For the most part, that was a consistent interpretation until more recently. The current board has been a little more liberal in interpreting what street level means. The problem for us in licensing is that we didn't know what their standard was. How liberal can you be before we would just disapprove it before it even gets to the board on the street level? So the members have issued an advisory, and in a nutshell, and I'm going to highly recommend that all of you go back and actually look at these advisories. I would say not all of them have yet been posted. Secretary's office is short-staffed right now, more so than it usually is, and they're trying to catch up, and they were kind of swamped with all these new advisories. It will take a week or two, perhaps more, to get all these on the website, but I encourage you to look at them all. Anyway, the new advisory indicates that even if the entrance is raised from street level, you have to go up a few steps to get to it, it will still be considered on street level, on the public thoroughfare if the entrance can be viewed from street level. And essentially that it's on the first floor of the building. So the only thing you could have beneath it would be a basement. Right? This is not going to stretch to being able to put a package store on the second floor. And as long as you can see the entrance, that counts. This has to be a, first floor / ground floor premises, but can be elevated by, a stairway, a ramp, so forth. I would note that in that same advisory, it's going to, and this one may have already been posted, it's going to repeat some prior guidance given to the industry on package stores. We're just kind of consolidating it. So there is a provision in there talking about stores that have double doors. Right, so you get, instead of having one single door, you have two double doors. Two doors, and at what point do those two doors become two entrances rather than one entrance? There's also language in there about package stores in enclosed malls. We all know that many stores and malls don't have a doorway; they have a wide entrance, and this advisory just repeats the prior guidance from the members about how those can be licensed. All right, personal questionnaires and who has to be disclosed on the license. So the law requires all the officers, the directors, stockholders. And as you know, if there are more than 10 stockholders, then only those with 10%. So using our the power we have to eliminate certain requirements, we're cutting out the directors. You no longer have to provide us with the names of the directors. I will say that a lot of you don't already, so it's no big deal. We need the principal officers, the president, the vice president, secretary, treasurer, the CEO. Okay, we don't need the senior vice president in charge of marketing. Right? If there's no principal vice president, for lack of a better term, that's fine. Okay, but we need the president, the secretary, the treasurer, if there's a CEO of the applicant. Right? And my next topic is going to kind of reinforce what I mean by that. And then with respect to stockholders, we want whoever has at least 10% ownership directly or indirectly of the entity. So this, what I'm talking about is mostly corporations, LLCs, with holding companies, right? This is something we've been doing for a while, informally. Now we've made it more formal, okay? So we don't care at all about anybody under 10%, whether there's 2 stockholders or 150 stockholders, right? We only want those who have 10% or more, whether it's directly or indirectly. So if the applicant's stockholder is a holding company, and then there's another holding company and another holding company, you need to drill back until you get to a person or people. And we want to know who the people are that own 10% of the applicant. Now, many of you who dealt with holding companies know that we've been doing this already, right? But that's where we're coming from with this. Right? We are also going to be looking for a personal questionnaire of any lender who is giving more than 10% of the financing. Now, other than that lender, all those principals I just mentioned are the ones we'll get fingerprints on. So we don't need fingerprints from directors. We don't need fingerprints from what I'll refer to as minority, less than 10% stockholders, right? Just those principal officers and those stockholders that I mentioned. That kind of leads to the issue of who can sign the documents. I see a lot of applications come through, particularly with holding companies, where the applicant is an LLC, the owner of the LLC is another LLC, and then the application will list the LLC manager, or if it's a corporation, the president of the holding company. That doesn't do us any good. All right. The applicant needs to have somebody who is a principal officer to sign paperwork. The LLC manager or the president of the holding company is not the person who should be signing the documents and listed on the application. We don't care who the president of the holding company is. Don't bother listing it. We don't care who the LLC manager is of the holding company, unless he or she has 10% ownership. So we need to know who the people are, who the individuals who are officers, manager, or LLC managers, presidents, CEOs, whatever, of the applicant. The reason this has become important is because just in the past, I think 2 months, I have dealt with 3 scenarios where I have had somebody attempt to surrender a license on behalf of the licensee. And I've gotten into back and forth with the attorneys about whether or not that person is allowed to surrender. Now, one example is I had an LLC that had 3 LLC members. No one was designated as the managing member of the LLC. So I don't pretend to be an expert in LLC law, but I know that how it's set up is supposed to be either you have a LLC managing member, or you can designate somebody who's not an LLC member to be the non-member manager. And if you don't do one of those 2 things, then all the LLC members are the ones who run the company. And we don't care whether or not they have 5% or if they're 10% or 90%. Okay, if in the situation I had, we had one of those LLC members who had less than 50% ownership, signed a surrender. Well, that license is surrendered. We're not going to get involved in a dispute between the ownership of the licensed business about whether or not that LLC member or that LLC member should have signed the surrender. Okay, so it's important for you to identify, okay, who the officers, I use that term generically, president, vice president, LLC, manager, all right, who the people are who are the people running the applicant business, right? Don't worry about putting in the names, as I said, of the officers of the holding companies. You just want to know, and I don't mean to keep repeating myself, but this is important. The officers of the applicant, and then those who have 10% or more ownership, directly or indirectly, of the applicant. Co-licensees, that's my next topic. So I know for years and years and years, we have been putting on managers or landlords or so forth who have gone over that 10% threshold of putting on as co-licensees. And I will tell you that the attorney in me has always been annoyed by that. Because if you look in the ABC law, it says we can issue a license to an individual, to a partnership, to a corporation, to an LLC. Nothing in there about co-licensees. So what is a co-licensee? I have argued in the past that it should be there should be a partnership between, let's say it's a hotel operator and the management company. Well, you can't put it, there's no such thing as a co-licensee. There should be a partnership. Now, I understand that then creates a huge problem for you because the lease is in the name of the hotel operator, and we require the lease to be in the name of the applicant, which would be the partnership. So, but in any event, we opened up, as we say, the old barn door to co-licensees. So the members have now officially recognized the existence of co-licensees. These are going to be the entities that, if you look at that third-party provider advisory, have to be listed because of the percentage they're getting from the business. Right? What we want you to do when you're filing applications, when there are co-licensees, management companies, food and beverage concessionaires, the landlord, the licensee, the actual licensee should be listed first. Okay, and then list the other entities. Okay? Now, this is important because this is going to drive other applications you may have to file. Right? So the advisory on co-licensees says that you can change the co-licensee by an endorsement application. You don't, it's not going to be, but if you're changing the licensee, that's going to be a transfer application, most likely. So we need to know who is who and be able to keep track of that without going into all the minutia of the agreements between the parties to figure out what the arrangements are. You should disclose that, like, even in a one-page document, explain, who is who and why they're on the license, who's going to be the co-licensee and so forth, right? When we look at those applications, then we're going to do the review of the licensee, its officers, its stockholders, and then look at the co-licensees separately. But we won't, there won't be any need for a partnership agreement if you want to swap out one of the co-licensees. As I said, it's just the endorsement applications, nothing more than that, which has been our practice. Warehouse permits. So those of you who deal primarily to do with package stores on a regular basis, you know that whenever you have that basement space and you can't get from the package store downstairs to the basement, you have to go outside. And even with some on-premises establishments, when there's maybe a basement storage area you can't get to from inside, or you can't get to from anywhere on the licensed premises, whether it's inside or outside, we've been making you get a warehouse permit. That's no longer going to be required if and I'm going to refer to it as storage space because it can only be used for storage. If it's adjacent to the proposed licensed premises, that means touching it, okay, whether underneath it, next to it, whatever, and you can get to that storage space either by staying on property controlled by the applicant/licensee or public space. That includes the hallway of the building or going outside, to the to the exterior edge to the stairway, right? You can't go through another business. It can't be the a building, a storage building that's down the block or separated from the premises. But if they're connected, you don't have to get the warehouse permit anymore. Now, we're still sorting through how we're going to deal with those applicants who currently have warehouse permits and how we can either just have them file an alteration application to add the storage space, right? And then get rid of the warehouse permit, unless for some reason they need the warehouse permit. Perhaps they're storing other entities' product in there, right? Again, though, this is only for use as storage space. The fingerprint waiver we just did. So I know that informally, my predecessors and deputy commissioners have, on rare occasions, allowed for the waiver of fingerprints under certain circumstances. This was never something that was officially sanctioned by the full board, but it wasn't, disapproved. The full board did not indicate its displeasure with it, but so we just formalized it. So the deputy commissioner now has the ability to waive the submission of fingerprints for good cause. Inconvenience to your applicants is not good cause. Right? Someone's already tried that. Okay. Just because it's not convenient to get fingerprints is not good cause to waive the fingerprints. I'm talking, and this is just examples. We've had applicants who have some physical restriction that either prevents them or makes it very difficult for them to get fingerprints, or situations where the applicant may be in a location where it's not, getting fingerprints is not readily available. All right. This is going to be a case-by-case situation that we'll review. All right. But it is not meant to be a complete runaround to avoid getting fingerprints done. Earlier in the year, we issued a advisory about food courts and common seating areas. Again, this was something that was being done informally by my predecessors as far as when they would allow a group of licensees in a food court, hall situation to share a common seating area. There is an advisory out there now. I'm not going to go into the details of it. I will say that it is consistent with how my predecessors have dealt with these situations in the past, but now at least the full board is signing off on what the standards are. So I would just direct you to that if you have that kind of situation. Finances. We are still going to have our list of expenses, financial disclosure form. We're going to edit that a little bit to make clear what expenses should be listed. I can tell you that the one expense that's almost never listed is what they're paying you. And that's an expense that should be listed. You should also have your client look at, because we're not going to be looking at banks. We're not going to require bank statements now automatically. We're going to be looking at financial disclosure form. And based on that, and based on the other review of the application, we're going to decide if we need bank statements. So if you have an applicant and he or she or they are indicating they're going to invest $250,000 into their business, and for example, their questionnaire says they've been unemployed for 20 years, we're going to wonder what the heck's going on. Right? So we need full disclosure on that expense form of what the expenses are and where it's coming from. Okay. I'm going to guess 95% of applications, we look at those and everything looks in order, and the bank statements are just an unnecessary step that you and your client have to go through in the application process. Right? So is there some risk involved from the authority? Perhaps. But it seems like a reasonable risk to take. And as I indicated before, the representations your client makes in those forms are binding, and we're relying on those. And if they're lying to us and we find out about it, they're going to be subject to disciplinary action. So my advice is to give as full disclosure as possible on those documents. That will lead to less questions by us and probably fewer demands for bank statements and so forth. I mean, you'll still have to submit the loan agreements and those kind of things, but we're not going to be looking for the first 3 months or the 6 months or whatever of bank statements. Outdoor space. So now that and I'm going to refer to the New York City Open Restaurants program because that's the most well-known, but for the most part, most municipalities have some version of this. It's now been extended, at least, for some point in time. So if you have an application, if you are using outdoors, if your applicant intends to use outdoor space that they control, the backyard, the side yard, the front yard, okay, but it's not municipal space, that needs to be on the application. It needs to be shown in the diagram. It needs to be disclosed in the establishment questionnaire. Right? Whatever conditions, whatever method of operation that you're disclosing, okay, is going to control what happens there. If your client is using municipal space, and at least for the time being, that municipal space can either be contingent or not contiguous to the licensed premises. That is covered by the open restaurants program in New York and other programs elsewhere. It does not need to be on the establishment questionnaire or in the diagrams. Right? You will need to get whatever authorization the municipality requires, whether it's through the New York City Open Restaurants program or whatever. And we have that email address where that information is sent to. Keep in mind one thing, and members made this clear at the last board meeting when this advisory was approved. If your client submits a stipulation from the community board or from another, your applicant's municipality that addresses the use of outdoor space. And again, remember, those agreements, unless modified by the members, become conditions on the operation of your client's premises. So if you submit a community board stipulation on a 500-foot wall case, and we approve that, and we're approving it in part because the community board signed off on it, if that stipulation says no use of outdoor space, then you need to come back to the board, to the authority rather, to get permission to use the open restaurant space. If you had an application that went to the full board and the full board said no outdoor space, or the full board said no music outside, and your client wants to have music in their open restaurants area, you need to go back to the authority. Right? So those two scenarios, where you submitted a municipal stipulation that restricted outside space, and you now want to have the municipal, open restaurant space, or the member said no outdoor space, right? If you submitted an application to us and there was no community board stipulation, and you said no outdoor space, and it got approved without going to the full board, you're fine. You can go through the open restaurants program. It's only the ones that went to the full board or you have a community board stipulation. The restroom waivers, okay, we've sent, I don't know, a half dozen or more just since I've been in licensing, where the only issue before the members was the restroom waiver, because occupancy was more than 74. Going forward, that issue does not have to go to the members. I can, and staff I designate can, waive the two restroom requirement. We're, using the same standards that the members have used. There may be some that will still go. Right? We had an example at the last board meeting. We had a park in New York City that had an occupancy of 6,000 plus. And then the restrooms were another 150 feet away from the park. I would have sent that to the board anyway. I believe I made a joke about the fact that I was applying the old man standard, because I'm an old man now and I can use that. is that if I'm in a park with 6,000 people and then I have to leave the park and walk 155 feet, that's a lot to me. So I'll let the board decide that. Right? But for the most part, the waivers will be granted by licensing. And if that's the only issue, your application does not have to go to the full board. The review of the 500-foot decisions. So we've had a number of ALJ decisions where the applicant discloses, yes, I have a stipulation with the community board. Here are the terms, but they don't provide the community board stipulation. Right? Either they forgot to, or maybe the final stipulation wasn't ready yet. And the ALJ says, I would have approved this, but I don't know if there's actually a stipulation or not. So that's an example of a situation when the members have now said the supervisor of the hearing bureau, which right now happens to be me, can, for lack of a better term, override the ALJ if the applicant submits that community board stipulation after the hearing. Right? Because the ALJ had said, hey, if I had that document, I would have been okay with this application. So that's what we're talking about, is missing something that was missing that the ALJ said, if I had it, I would have approved, or I would have found in favor of the applicant. I want to distinguish that because I've already gotten some inquiries about this. I want to distinguish that from the ALJ who says the applicant, in my opinion, did not satisfactorily answer questions about, say, the impact on parking and noise and traffic that the applicant's going to have on the neighborhood. That's not missing information. That's the ALJ saying you didn't give us enough information. Your answer was not sufficient. Right? This review process is not going to let me or whoever eventually takes over the hearing bureau override the ALJ, because this wasn't a situation of you disclosed a stipulation, but you forgot to submit the document. This was you gave an answer and it wasn't good enough. All right, so that's the distinction I would make for all of you. Going back to earlier in the year, there was an advisory about the newspaper publications you have to issue. You have to send out when you first file your application. Please go back and take a look at that. I will say that both the licensing bureau and the applicant representatives got very sloppy over the years with these things. And I mean, I've actually seen applicants where they wait until the conditional approval is issued and then they submit the newspaper publication, which is supposed to be done at the beginning of the application process. ST permits, just very quickly on those. As you know, new light applicants in New York City are now eligible. Right? There are some restrictions for those who are subject to the 500-foot law in New York City. The one thing that the members did address, some of those restrictions have to do with the location having been licensed and having no cancellation or revocation within the past 2 years. All right, so the members clarified that we're going to use the date the check was, the application was received and the check cashed by the lockbox to start the look back period. And for those of you who represent manufacturers who are also getting on-premises licenses, right, we're trying to clarify, if you can now get a temporary permit to operate the manufacturing site. If you're applying for an on-premises license there, you can get an ST for that location. But if you're applying for a branch office, since there is no temporary permit for the branch office, you can't get a ST permit for the add-on on-premises license. Right. So with all that, and if I haven't confused you enough or bored you enough already, I'm going to open this up to questions, and hopefully if it gets too disorganized, I'll kind of do it in order, but I see some hand, oh, everybody's using the hand thing. I like that. I don't know how to use that myself. I see, okay, so I'm going to start off. Aurelia, your hand popped up first, so I'll go with you.
I was quicker. I feel like I'm at the buzzer in Family Feud, but okay. Hi, everyone. Thank you, Mr. Donahue. This was amazing. Your attention to detail and helping us is really good. So I have two questions. One is, how do we deal with 10% and not be considered availing? Because we have so we don't report that the guy has 10%. Is this availing? Because then I come in and see an investigator. The guy says, hey, I work here. I manage. I'm part of the ownership. And then you got Charles Travali showing up at their door. How do we deal with this?
I'm going to defer on investigations. What I would just say is if there's an agreement where there's a percentage, okay, it should be disclosed at the beginning, even if it's under 10%.
Okay.
Right. Then there's no problem. Okay. Then we get it because that form's going to say, is there a percentage involved? Say yes, but then you can say it's under 10%. That to me is the easiest way to approach it.
That's very fair. The last question I have. So under the attorney-client privilege is how much we get paid protected. I don't have my license to practice. I'll have it soon. And then what they don't pay. Okay. And what if we disclose and they don't pay us in full? So then have we made a fraudulent description on the application? Have we made a false statement?
That form lists expected or anticipated expenses.
And why is this relevant, what we get paid, other than to add it to the full pot and say it's part of the expenditures? I'm not sure I want to itemize it.
Well, because it is one of the expenses, just like anything else is one of the expenses. We're not trying to govern what you're being, and it's going to be, it doesn't have to be itemized. Okay, there's just miscellaneous expenses. It gets added there.
Okay, so we don't have to itemize it. Okay.
We're not asking to see your itemized bill, okay?
Okay, thank you, everyone.
Yeah, all right. I'm gonna be a little informal. Chip?
Hi, thanks. I had a question about the certificate of occupancy. I have an application that had conditional approval that included both the certificate of occupancy and a maximum occupancy certificate. Can you clarify whether or not the advisory would also obviate the need for a max occupancy certificate?
Yeah, we're just going to want you to disclose on the establishment questionnaire what the occupancy is.
Okay.
Right.
So that can just be done on the form without the actual certificate.
Right. It's on the establishment questionnaire. Whether or not you exceed that regularly or on occasion, that's an issue between you and the building department or the fire department, whoever's enforcing that.
Okay, and another quick question on the expenses, what I'm pretty sure I know the answer to, but I just want to confirm. When those expenses should include expenses that may have already been incurred.
Yes.
At the time of the application.
Yes. So like if they're buying the property or anything that's been incurred or they expect to incur to start off the business. I think you all have seen at board meetings the chairman question applicants when they put down my total investment in this business is $5,000 and for miscellaneous expenses, and then they see that the lease is $7,000 a month, so we know that they've at least put down $14,000. All right. Don't put your client through that. Right. There's no need for it. Just disclose the expenses and the what's being invested.
Okay. Thanks very much.
John Springer.
Thank you. On the second page of the applications where they ask for principals. So let's say I have 4 principals and one has 80% and the other 20% divided among 3 people. So they're less than 10% each. Do I only list 80%?
Yep. Yes, sir.
Okay, and the examiners aren't gonna say, what about the other 20%?
We are going to ask for, if it's a holding company and stuff to explain, but in your scenario, no, you only have to list those. One thing I do want to point out is that, so let's say you have that scenario. And so one of your people who's under 10, then buys, so they go over the 10%, that's a corporate change application. Right? So if I have an owner who has less than 10%, but then increases their share to 10% or more, that's a corporate change. If I have a principal who has 10% or more, but is selling off and is going to become less than 10%, we need a corporate change for that too, so we can take that person off the license. We also need a corporate change application if, let's say, John, in your situation, the person with 80% is going to sell 5% to those other people. They're still going to stay under 10%, but he's dropping down to 75. We need to know that. We need to keep updated as far as what the actual ownership structure, ownership percentages are of those above 10% or above. But on the form, John, you just put down that one person. Okay.
Thank you.
I'm going to be the first to acknowledge that it's going to take the staff time to adjust. Okay. And you might get initially a deficiency letter saying, well, wait a minute, where's the other 20%? Okay. So you may just want to add a note, like there's often an addendum to the second page saying there are 3 other people, none of them own more than 10%, or none of them own 10% or more. That's all you need to do. Okay. Okay, let me go across here. Mr. Warbeck?
Yes, thank you. And Mr. Donahue, what a wonderful presentation. Thank you so much. This was excellent. I think the change on the no max occupancy certificate will be a huge help, because that's often a holdup for me. But just a quick question. Are there additional written advisories that will be posted to the website soon? I think there are still some that are forthcoming, correct?
Yeah, there, as I said, so unfortunately, in Secretary's office, these advisories all got done at the same time that Secretary's office, as many of you know, because I complained about it when I was Secretary, is short-staffed. And right now, the Secretary to the Authority, Mr. Roper, I think is actually the only person there. The one main person is on vacation, a long overdue vacation, and a support person is out sick. So he's by himself right now. So he is trying to get these out as quickly as possible. So I would anticipate that the ones that have not yet been posted should be posted shortly.
Okay, and these are on if we wanted to watch the YouTube videos, these are at the July 27th and August 31st meetings?
Yeah, there were some, members had requested some changes to the non-substantive language of those, and he was getting those addressed, and then they were going to be issued. So he's working on it.
Okay, thank you so much.
Marty?
Thank you, and I also applaud you in what you've done this morning. It's extraordinary, and obviously your knowledge is, I've always recognized that. But I have a question. Actually, my question relates to what you said.
Well, that's good.
No, yes, no, but specifically when it deals with these holding corporations or holding LLCs. The reason for holding LLCs, for layers of LLCs, is for tax purposes or for REIT purposes, REIT purposes. And many times, none of the underlying holding companies, corporations, have any managers or members. It only goes to the top, and that's where the manager or managing member comes to play. So my question is, are you telling us that we have to create some sort of manager on the actual applicant? Because that actual manager will have no percentage of the business, or he might, but
Well, let me ask you this. How can you have a business entity that has nobody who can do anything on behalf of because a holding company can't sign a document, right? So
But
there
that's-
should be,
that-
it could just be, it could just be whatever title you give him, a CEO, a president. There needs to be a person, okay, who's going to sign the renewal forms, who's going to sign the alteration applications.
No, but okay, so we're going to create a title. And the fortunate thing about LLCs is that it's very loose in the sense that you can create some sort
Yeah.
of title. I get
Mhm.
that. But you're going to understand that that title, that person, doesn't necessarily have any membership, right?
Well, yeah, but that's allowed by the law. The law
No, okay,
allows.
but as long as someone is designated as with a title, whatever that title is, and is in the applicant corporate LLC, that is the person that signs everything, and that is the person you want to PQ
Yeah.
from, other than
Yes.
the more than 10% stuff.
Yeah.
So
Mhm.
you've answered the question relating to anyone under 10% or 10% or less does not have to fill out a personal questionnaire. But you also stated with respect to lenders that if they fund more than 10% of the project, they have to file a PQ. My question relates to the financial page, and it's not a lender. It is one of the under 10%, or most of the under 10% that put in most of the money. Is that going to require a PQ regardless of the percentage that they own? Because you know in your financial disclosure thing, you say has the PQ been supplied? In other words, what I'm trying to say is there can be somebody, let's say a prominent chef, that doesn't put a dime in because he's the chef and that's why they're coming to the place, and he gets all of these people to invest in the business, but
Okay, so
none of them have more than 10%.
If they are a owner, an LLC member, a stockholder, whatever the situation, and they ownership interest is less than 10%, they don't have to be listed. If it's somebody not on that, not an owner, it's a separate individual who is lending money or gifting money, and that is more than 10% of the total that's shown on that financial disclosure form, that's the person we want the personal questionnaire from.
So let me, I just one more time. I'm sorry because I'm slow. You're telling me that if a prominent chef, we'll use that as the example, gets 8, 10, 20 people to invest $1 million, he doesn't invest a dime. They don't have to be listed, and you don't need personal questionnaires on any of these people. We're just telling you that it'll take $1 million.
Yeah, they're investing, so they are owners of the company.
Correct.
So how much of a percentage do they own?
They own less than 10%, but they're donating all, they're putting in all of the money.
Right.
I mean, if what you say, I'll go with what you say.
If they're putting in, if their ownership, okay, put aside how much the monetary value of their investment is. If their ownership interest is 10%, is less than 10%, they don't have to be listed.
And they don't have to list them on the financial disclosure page because you have a thing.
No. Well,
We put in $1 million and
No.
the only PQ.
Marty, the source of the funds has to be listed there. What I'm telling you is
Okay.
they're not gonna be listed as principals.
Okay, I hear what you're saying. That's a revelation to me. With respect to what you said about ALJs and there are 500-foot reports, I heard what you said.
I'm not gonna go beyond, just so you, beyond the scope of the advisory. All right, I don't want to discuss the 500-foot hearings and ALJ decisions beyond that.
No, but this is related. I want to know if you could supersede this or you know, if let's say a community board recommends approval, and they recommend an approval for 4 a.m., just as an example. And then the ALJ writes in his or her report, I don't find public convenience and advantage for a place to be open past, let's say, 2 o'clock or even 1 o'clock, or whatever he or she may say. Do you have the right to override that?
No.
So in other words, that would be a disapproval based on public
Yes,
convenience
right.
and advantage.
That's the ALJ based on the record making a decision. That's not the ALJ saying, you know, if you had sent this to me, I would have ruled differently.
No, yeah, but in a sense, all right, because the ALJ does have a copy of the community
But
board's.
it goes to the merits. It's
All
not
right.
something I can overturn.
All right, no,
Right.
then,
Right.
thank you, thank you.
Okay. Mr. Korngut.
Thank you, Mr. Donahue. I just want to echo what everyone else has said, thanking you for these efforts. They're going to be very helpful. I have two quick questions. On the C of O waiver, I mean, this is kind of implied, but a lot of us signed on the original waiver. We signed in our personal capacity as attorney, that we would deliver this document within 2 years. I'm assuming those are all effectively torn up or thrown out.
Yeah, I'm not, you don't have to worry about when it comes up for the renewal, us looking for it, because you've been relieved of the obligation, for lack of a better term, to submit the documentation.
Okay. And another quick question. Previously, where there were more than 10 principals and certain individuals owned less than 10%, oftentimes we submitted a declaration that the additional owners were not subject to statutory disqualifications or anything. Is that still going to be required?
You can submit it. We're not going to require it, but the advisor makes clear that
It still applies, right?
it still applies.
Right.
Okay? Whether you affirmatively say it or not, if there's a tied house issue or something like that, your client still has a problem.
Okay. Understood. Thank you.
Mr. Kozlow. You're muted, Mr. Kozlow.
There we go. How's that? Okay. First, Tom wanted to thank you also, like everybody else. Thank you for sterling effort to gather all this material together, then shepherd it through the members, which is not easy. It's not easy to do either, then ultimately get it published. So I wanted to thank you. Second thing is, when it comes to the lender donors, it says any individual who providing, et cetera, et cetera, et cetera. Unfortunately, entities are individuals as well. We're talking about a bank. I assume.
No, yeah. So just for clarification, if it's a commercial institution, or a recognized, financing company, we never ask for anything more than that. Okay. But we're talking about individuals, or those rare occasions when we see some funding company that, for lack of a better term, looks a little sketchy. And then we're going to take a deeper dive into it. But yeah, for the normal banking, financing, commercial institutions that loan money, we're not going to be asking for anything. And that's been the authority's practice for some time.
Again, in many instances, you have private equity funds and of that nature. They're not getting any, assuming they're not getting any investment. So it's just a loan. Again, we report it on the financial information. We report the fact we've obtained these loans from this funding entity, even though it may not be a bank, but it's still like a commercial bank. We report it, but what else would you want? Again, I don't think you would want anything from those institutions unless they're getting a percentage of the pie. That we understand.
Right. The only issue would be, and we've had this lately, is distinguishing the crowdfunding situations and whether or not they're equity or, and I'm not going to go into that right now, whether or not they're equity or loans. Right.
That's like the example I'm giving is I outlined they're not getting any equity interest, but they are certainly a loan, and they are not necessarily a bank. They're not a finance, what you call it, but they are financing institutions that do this routinely. They're not commercial banks, but they're very close to commercial banks.
Yes.
Okay. Thank you.
All right. Colin?
Good morning. Thank you. And I'll echo everyone. I really appreciate this outreach from the authority. Two questions, one to do with personal questionnaires, a situation where the applicant is an LLC and you have trusts that hold membership of the LLC. You're still looking to get all the way back to the trustees.
The trustees, yes. And I will say, although kind of off topic, I know there's that trust stipulation, and I'm going to ask for that to be revisited. But yes, we're looking for the trustees. From my perspective, we're not interested in the beneficiaries. I know that may not be consistent with the current stipulation, but yeah, we're looking for so if the applicant itself is a trust, The trustee is the person we're issuing the license to. If the stockholder, the LLC member is a trust, it's the trustee.
Okay, it's great to hear about the trust stipulation, but for the moment, if I'm submitting an application for a client in the next couple weeks, should it still include that?
Yes, yes.
And the second question, I don't know if you might be able to give us a peek inside. Any idea what the time frame is at the moment for processing licenses and at least getting out temporary permits for applications that are coming in?
The temporary permits, we are trying to get them done within 3 weeks of what we say the application being booked. So let me explain the process to those who may not know. The application goes to the lockbox, which is the bank in now Philadelphia. The application comes to us, the hard copy of the application. We then have support staff who, what we call book or enter the application into the system. Right? That's usually a couple days after, I shouldn't say it, we get the application within a couple of days. Unfortunately, right now, because of the increase in applications we've gotten, it could be 3 weeks before we get that application booked into the system. If there's a temporary permit attached to it, it immediately goes to review. Have someone look at it and review the temporary application. So we're talking somewhere 3 to 4 weeks from the time it gets to the bank until we can hopefully get that ST out the door. The application time frame for the license applications, unfortunately, has gotten a little longer. We are right now, I think we have a 30 or 40% increase in the number of applications we're seeing. I think many of you know we're trying to fill some spots. We got authorization to fill 30 new spots. I've got 10 of them filled so far, and this has been 6 months into the process. So, and hopefully with the addition of the new staff, the impact of these advisories, and once our new licensing program goes online, hopefully early next year, that there'll be a significant decrease. I just have to ask you all to be patient. And for any applicant who is eligible for a temporary permit, to file for the permit.
Great, thank you.
There are still, John, you didn't have any more questions, did you? Because your hand is still up there. All right, anybody else, anybody have any other question? Yeah.
I do.
Well, hold on, Adrian. You're muted, Adrian.
Thank you so much. This was excellent. And so many anachronistic changes, long overdue. So one question I have is concerning the restroom waiver. You mentioned that now that DC licensing can waive the restroom waiver, restroom requirement to bathrooms. Is that, that's just within the authority? If you have a municipality that says you must have 2 or more restrooms if you're serving alcohol, that you're not able to change that. Right?
That's between the applicant and the municipality. So that's the same as the certificate of occupancy, the letter of no objection. Those things are between the business and the municipality. Same thing with the workers' comp and disability. There are agencies that have jurisdiction over that, and that's up to them to enforce.
Okay. And one of the participants mentioned just a bit earlier about max occupancy. Are you still requiring max occupancy certificates or numbers, just numbers, or not at all?
We just want the number on the establishment questionnaire.
Okay, very good. Thanks so much.
Okay. Anybody, is there somebody else?
Yes, Mr. Donahue, it's Josh Werbeck. Just a quick follow-up on the temporaries. On the temporary permits that are subject to 500-foot approval, when you hear that the approval has been granted by the ALJ, you're going to approve the temp even before the written decision comes out. Isn't that right?
Yes. Yeah,
Okay,
so
great.
right. So what's happening is the ALJs are sending me emails with, they usually get assigned a group of them at a time, 4 or 5. They're reviewing them, getting back to me, and then I'm sending an email to staff with the ones that have an associated temporary permit to let them know they can go ahead, assuming there's no other issues, that they can go ahead and issue a temporary permit.
That makes total sense. Yep, thank you.
All right. Anyone else? Well, I do want to thank all of you. I know that, you've got busy schedules and, clients who are actually paying you rather than having to listen to me for free for an hour. Probably should be paid to have to listen to me for an hour, but that's another issue. So I want to thank you all for taking the time out. If you do have follow-up questions, feel free to, send me an email. I think I've already gotten a few as it is. All right. So thank you very much.
Thank you.
Thank you.
Thank you.